So my view was, I want to go to court to ask the courts, can a prime minister use their prerogative powers, these Henry VIII powers, in this way to change our rights? And ultimately, the Supreme Court in the country said, no, they can't. And I won in the Supreme Court. So then that triggering of Article 50 had to go before the court, the Parliament. Parliament voted it through and the process started. So that was what the first case was about. But then the second case, where Prime Minister Boris Johnson was also going to bypass Parliament because he couldn't get the Brexit deal through Parliament. So what he was going to do was a different way of using his Henry VIII powers. So one of the powers the Prime Minister does have is to close down Parliament for our session and then open it for a new session. That's called a prorogation of Parliament. So you can do that. That's totally legal. All prime ministers do it, but they can't do it. They can't close down Parliament for a prolonged period of time if the reason is to push through a deal legislation rules that Parliament wouldn't approve of. Okay. And that's what Boris Johnson was trying to do. He was trying to close down Parliament to push through the Brexit deal he wanted to get through without Parliament voting on it. So again, I thought, well, this is illegal. You can't do that. And so they're sound difficult, but they're actually quite basic rules of parliamentary sovereignty, which every country in the world who copies our British Constitution and Parliament lives by. And so the case was very large in the UK, but it was also had implications for every other jurisdiction that practices a British form of jurisprudence, separation of powers between the judiciary and the law and the parliaments, and the way parliament, democracy and sovereignty works. So the implications, so both cases are still now, it's called Miller 1 and Miller 2, are actually used